Before I get started, will you mind signing this? It's a non-disclosure agreement. No big deal, right? Hello everyone, my name is JD Houvener, a registered USPTO patent attorney, and I'm the managing partner and CEO here at Bold Patents Law Firm. And today I want to dive in and help you better understand non-disclosure agreements and when inventors should use them. And before we get started, I want you to know the timestamps are down below in the details. You can jump ahead in the video to the section that you want to, and there's even a blog article I wrote on our website. So what is a non-disclosure agreement, and what is it used for? Well, a non-disclosure agreement is the same thing as a confidentiality agreement. They mean the same thing. The secret here is that they're contracts. Don't forget, it's not just a handshake. This is a legally binding contract, and it's what's going to help you have a foundation for confidentiality moving forward. When you're starting your business or you have an invention, this is the hallmark. This is the foundation of what you set your company on. You got to make sure that you protect it. Now, I want to take a quick mention of our blog article. Go visit our website at boldip.com/blog. I wrote an in-depth article about what a non-disclosure agreement is, what aspects of the contract itself you need to be concerned about. So visit the blog if you want more detailed information. Something else I want to mention too about non-disclosure agreements is because they're contracts, they are governed by state-specific law. Every state has their own laws about contracts. And so you must make sure that you're working with a local attorney licensed in the state that you're residing in and the other party is residing in, if you want it to be binding on all parties. So this is a major reason why investors typically won't sign non-disclosure agreements. They see so many ideas pitched at them, they don't want to get stuck being liable, having known information and sharing it with others. The other issue is that they likely are very difficult to enforce. You're again dealing with a contract that's likely between parties that reside in different states. And also, I've seen this quite often, inventors talking with parties over in different countries. Could you imagine trying to go to, let's say, China to enforce your non-disclosure agreement in a Chinese tribunal? Good luck. So when do you use a non-disclosure agreement? This is the heart of what I wanted to get to. Inventors oftentimes come to me as a patent attorney. They confide in me in their invention, and that's wonderful. But even before they talk to me, they've usually talked with other people. And that happens, right? You got a brother, a relative, a close friend. You want to be able to bounce the idea off of someone in confidence. This is the tool to use. Now, even if it's, like I said, a friend or family member, it may seem awkward to shove a contract in front of them, but it's a great way to practice because you need to have that level of seriousness with your invention. Now, certainly you may not need that with family. And I said, I would encourage you to practice it, but you will need it with third parties, whether that's someone that's helping you develop the product, prototype it, or help maybe be a co-inventor someday. Now, that's all pre-filing. So we do recommend that you work with an attorney to structure that non-disclosure agreement to get the written language down correctly for the state that you're in. Once you file your patent application, there actually are reasons to still use a non-disclosure agreement. A provisional or a non-provisional patent application will actually lock in your invention, but know that it's only locked in so far as what was disclosed in that provisional, okay? So as soon as it's filed, yes, you're patent pending on that subject matter. But let's say you likely will, see improvements in your invention down the road. Those bells and whistles that you add or you get feedback from customers on, that needs to be kept confidential because likely you will be able to seek second patent application or an improvement application on that core invention. So keep all those extra learnings and improvements confidential, and if you needed to disclose them with a third party, treat them just like a brand new invention. So I want to tell you a quick story about one of our clients that we worked with just last year. They came to us when we first got to meet and they said, oh yeah, JD, I really need help with this new partner of mine. He's going to be manufacturing this product for us. It's a quick confidentiality agreement. That's what I need. I said, well, has he or she or this company sent you any documents? And he said, well, yeah, here it is. And I'd start to look at the contract that he sent, and it, of course, a little bit more murky. And it turns out that this contract was really taking ownership of this inventor's product. So they're not only just manufacturing it, but they wanted the rights to be able to sell it to third parties. Yikes, right? So make sure, of course, you're looking at your contract, but know to ask about confidentiality. And then third, talk with an attorney because they're going to be able to spot issues well beyond confidentiality. And in this case, patent ownership. All right, so I want to summarize all 6 areas I just talked about. Again, a non-disclosure agreement, similar to a confidentiality, just a nomenclature thing. They're state specific. Don't try to get investors to sign them. You need to use them pre-filing and post-filing. And don't forget to work with an attorney to help you spot issues that may not be so apparent. Last but not least, I want to give you a copy of our book, Bold Ideas, The Inventor's Guide to Patents. It's available right now online at boldip.com/free.